with only parents. Okay, single person, not married, have parents. So who gets the assets? 100% to the parents, of course. Okay, under the Distribution Act 1958, 100% will goes to the parents. Okay, next. If the customer have only spouse, but no parents, there's no issue, no children. Of course, in this case, the spouse get 100%. Okay, next. What if the customer do not have parents and he or she is the widower, and only have issues, only have children? Of course, 100% goes to the children. So only under these circumstances, all the asset will be passed to the respective person or family members 100%. Okay, but next, okay, let's see the next layer. This is the most common family type around us. They still have parents, they are married with spouse, and they have children, right? Even our friends and family, nearby, we have this type of family type. So how is the distribution managed look like? This is how it looks like. It is not 100% to spouse, which is most people misunderstand that. I have parents, I have children, yeah. Of course, if I pass away, everything goes to my spouse. It is incorrect because if you do not write a will to will everything to your spouse, it will go like this. Your issue, which is the children's, will get 50% of your asset. Oh, yeah, children gets more. And another 25%, it will goes to your spouse. How about another 25%? It will goes to your parents, equally shared. Yeah, equally shared. Everything. Movable asset, like cash, bank account, investment, share account, everything. And also house, property, apartment, your land, it will be distributed according to this percentage. Okay, so now we see the next layer. If the client have spouse, have parents, but not yet have any children, the parents and the spouse will be equally shared. Yeah, the spouse is not taking more than the parents. Yeah, 50-50. Okay, now next we see the next layer. If there is no parents, no longer parents around, the only spouse and my children, okay, 2/3 will give to my issue, 1/3 will give to my spouse. Okay, then you can see. Now, go down another layer. What if I do not have parents, I do not have spouse, and I do not have any children? Who will take my hard-earned assets? First layer, okay, this estate will be distributed according as this order. First layer is the brothers and sisters, which is the siblings. Okay, imagine a person do not have any, did not have a good relationship, good term relationship with the siblings. Do they want to give their asset to the siblings? Of course, no, right? So if they want to give to particular siblings, they must write a will to state the wishes who they want to give it to. Okay, now, if there is no siblings, we go to the next layer, grandparents. Yeah, if there's no grandparents, we will need to see uncle, aunties. So now you will understand why in the drama movie where we see there is some during a funeral, they are during a funeral, there are many uncle, aunties coming, okay? Sometimes the one that you don't even never seen before, so they come over, So to check whether, hey, is this person have thanks of kin? If no, I'm the uncle aunties for this person, I have the rights to claim for the estate. Okay, so if there is no uncle aunties, they will see another layer, great grandparents. If there's no great grandparents, another layer, great grand uncles and aunties. Yeah, and lastly, if there is no next of kin of this person who will handle all the estate, government, will have the rights to take over the estate. Yeah, except, okay, I would like to highlight, except for some land which is under, for example, native land, Bumi Putra land, all these, cannot be taken by government. But other banks account, all those shares which is unclaimed, no one is claiming the estate, it can be taken by government. Okay. And for those, if you have any question now, please you can type into the Q&A box, yeah, or just type into the chat box here. Okay. Now, next question. Who actually really needs a will? Okay. Who is on your mind now? Who needs a will? Normally, people would think only the rich need a will, right? Okay. Only the rich, those who have $1,000,000, those who have 10 cars, those who have 10 properties, those people need wills. I do not need because I don't have anything. Okay. So to be, clear about this, okay, I would like to emphasize that just like the AirAsia tagline, yeah, AirAsia tagline, everyone can fly. For us, for myself, I think everyone must at least have a will. Okay, who is this person? I will break into a few category of from priority. Maybe the first group of people you need to talk to about estate planning or will writing is married couple with minor children. So most people think that writing a will is just to distribute my estate, yeah, my house, okay, my car, my bank account, monies, my investment, everything. But do you know that will also estate planning, planning for your future family members, especially for your minor children. Yeah, very young one, married couple. Okay, because why? For husband and wife, if any of them not, a double tragedy, right? Okay, just to say one pass away first. One pass away, the another person is the legal guardian, right? Husband and wife, if any of them pass away, there must be a person to take care of the children, which is the surviving parents. So the surviving parents will be taking care of the children as the guardian. But what if, okay, throw the question of what if to your customer, what if both pass away together? So who will be taking care of the children for the little kids, the minor? So husband and wife actually can sit down together, discuss among themselves. If husband and wife pass away together, okay, who will be the person, the best person to take care of the children? Okay. So next is the category of divorcee, those who already divorced, ex-husband, ex-wife. So who will take care of children, especially those with minor children, yeah? So who will take care of the children if the single parents not around? And how about those widower? Who will be taking care of the children? So it's a very important question. For will is not just to distribute the asset, but a planning for your children. Okay. Third is the single person. Yeah, single person where maybe this single person do not have any next of kin where they think is suitable to take over the estate. So who is the best person to inherit? So this person might have the in mind, there are someone that they want to pass the estate to. Okay, so how to do that? You need to write a will. Okay, so fourthly, the elderly, old couple or old person, they have this asset which is accumulated quite long time ago. So they need to pass to someone when they're not around. And somehow those elderly person, they are very afraid of what if I pass my thing, I transfer my thing, everything now to my children or to my grandchildren and they abandon me. Yeah, they just bring me to the old folks home and throw me there without taking care of me because I have transferred everything. For me, for them, I have no longer have any value. Yeah, I do not have any value already. Okay. Maybe you hold on. You give me 2 minutes. Yeah. Okay, so sorry about that. Okay, now we continue. Okay, so 1, 2, 3, 4, of course, now when you think of your family or think of your friends, think of your clients, they might have a group of clients which is under this category. Yeah. So fifth is actually you can talk to anyone as long as they have assets belonging under their names. Yeah. When you talk to them, they say, I do not have anything, but you have bank's account, right? You have one car at least, or you have property with your name. Or maybe when we think further ahead, you might have future inheritance from whom? Maybe from your grandparents, from your parents to inherit in the future. Never knows. Okay. Now, sometimes we think that we know all our assets. Like Nicole today, I know all my assets. I know I have 5 banks account. I have this, I have that. But are you really 100% sure that you know all of your assets? Okay. To ensure this, maybe you can log into this website, which we call eGumis. It's actually a website under Jabatan Accountant Negara Malaysia. Yeah. This eGumis is for you money which actually should be paid to you. Yeah. Recently, I just checked mine and it was shocked that I have a 70 ringgit unclaimed monies under the eGumis. So I claim back. It's quite easy. I take back the money in 2 weeks. So even if ourselves, even if ourselves do not really knows that, oh, I have this 70 ringgit unclaimed monies, what to say my family members, right? They won't even know that I have this unpaid money should be payable to me. Okay, so today, after today's session, or you just screenshot this website, you take a time to register your account. Okay, then you can check using the IC number. Okay, one day you can check 2 IC numbers as a limit. Okay, you can check anyone's anyone's IC, but only that person with the IC can claim for the asset. For example, for my account, I can only claim for my unclaimed monies. Okay, so please, if this is the case, imagine in future, imagine Nicole in future, when my family members do not know what I have, how can they claim my monies? How can they claim my assets? That's why there is a lot of, unclaimed monies goes to where? To the government, which is now ballooned up to 90 billion. Yeah. So please do not contribute your monies to the unclaimed money 90 billions. So take action today. Please check for your own. Yeah. If you have checked, you have monies to claim, you can give 5% to Nicole. Yeah, just kidding. Yeah, 5% to Nicole for giving up you these tips. Okay, no worry, just joking, just joking. Okay. So there is also some misunderstanding saying that Nicole, there's no need the trouble to do all the wills, list down my asset. Why need the trouble? Yeah, because there's a system to track all my assets. Okay, to rectify this, I would like to clarify in Malaysia, there is no system to check your assets. Yeah, the eGumis just now is just to check whatever that is not paid to you under your names. Yeah, in Malaysia, there are only 2 systems that can check what is your debt. Yeah, what you own to someone. Yeah, which is registered. Yeah, maybe under Bank Negara, your debts, your loans with the bank. Yeah, your loans with the entity. Yeah, so first is the secrets. Okay, secrets. You might log into the website to check. Okay, the e-secrets where you can get the report for all the debts. Next, there's another system to check what you are owning, which is the CTOS report. Okay, so in Malaysia, the only system to check your debts, but there is no system to check your asset. That's why when a person passes without a will, come across the problem of I need to go to all of the banks to check. Is for example, is my father have any bank's account here? Yeah, my father passed away. I would like to check. I didn't know. I do not know what my father have. Investment, bank account. I only know he have a car and a house. That's it. How about others? My father did not leave any messages, did not even share with me. So I need to check one by one. Go to the bank, check, go all around. It takes time and energy for you to do that. Okay. So who will be doing all this? Without a will, family members will need to appoint one person, what we call administrator. Administrator will be the one who, handle and manage all these things. Yeah, do all the job. Is a very, very, important jobs to handle and accept. So with a will, you actually have the executor where this is the person you appoint to be the trusted person to handle your estate. Okay. Administrator, you won't know who will be this person. Okay. But executor, you know, and you are the one appoint the person. Okay. Now, let's move on. Okay. So some of you might ask, Nicole, what is the story? Okay. Okay. Now, this is a story time. So previous training, we always share wills is important, will is important, but we do not know what will happen if they, your client or a person or their family might get into if they do not make a will. Okay, we see from another angle. Okay, before I share the story, I would like to read out the disclaimer here. It's very important disclaimer. The following stories, which I will be sharing later, is purely for case study discussion purpose only. Any resemblance to actual persons, living or dead, or actual events is really purely coincidental. Okay, really coincidental, yeah? Okay, now let us see the story here. Story number 1. Okay, the wife versus parent-in-law. Okay, so I do not state any names. I will refer the person as the wife, the parent-in-law, and the husband. Yeah. So the wife has a bad relationship with her husband parents-in-law. Okay. So unfortunately, the husband died in an accident without a will. So, sometimes, yeah, the in certain family members or they have this, taboo saying that, okay, wrong belief that the wife has bring bad luck to and kill their son. Yeah. So during the inheritance distribution procedure, they refuse to cooperate with the wife and deliberately made the thing difficult for the wife. So now we roll back to the Distribution Act just now. Okay, when the family have only parents and spouse, by right they are sharing 50-50, right? 50-50. So during the administrator, okay, of the estate, the wife actually need to engage with the parents, which is the parents of the son, the parents-in-law, to do all the procedure. So when they refuse to cooperate, things will get harder for them. They might, as well, some cases, right? The parent-in-law would seek for lawyer advice on, I do not want my son wife, yeah, the daughter-in-law to deal with their son's estate. They are seeking lawyer advice. I would like to be the administrator for my son estate. How can I do that? I don't want the daughter-in-law to deal with any monetary things. So this is the thing will happen if there is no will written, yeah, and it will prolong the arrangement of distribution the procedure. Okay, story number 1. Okay, this story actually you can share with your client, especially those with the same scenario. They're in the same kind of situation that they might be this type of thing might happen if there is no proper will has been made. Okay, next. Story number 2 is legal wife versus girlfriend. Okay, legal wife versus girlfriend. Okay, story 2. So the husband and his wife has been separated for many years, but have not yet divorced. Okay, and do you know that there are some group of people that thought that if me and my spouse has been separated for many years, for example 10 years, 20 years, we will be automatically divorced. Yeah, I assure that I have been heard this. The client told me I have been separated with my client, with my husband for a long time. We are considered divorced. But please tell your client that it's not automatically divorced, just like there is not automatically married. Okay? You must sign to get divorced. You must legalize the divorce. So for this case, the husband and wife still husband and wife because they have not divorced, but they are separated. So the husband now is currently the husband live with his girlfriend in a house name under his name Okay, the husband bought a house 100% under the husband name, so the girlfriend is living in the house together with the husband. Unfortunately, okay, the husband died in an accident without making a will. So now the legal wife apply for inheritance distribution and own her husband's house and then kick the girlfriend out of the house. The girlfriend gets 0, nothing. So legal wife versus girlfriend, in this case, the legal wife win the case. Okay? So story 2. Now, story number 3, my wife a gambler. So a couple have a child. The wife is a gambler. Okay, the husband died. Okay, for story 1, 2, 3, you will hear a lot of husband died. Yeah. Okay, but it's just a story. Yeah, the husband died in an accident without making a will. Again, so the wife applied for inheritance distribution, of course, and then maybe how much is the inheritance? We might say 1 million. Okay, then gamble away because the wife is an addicted gambler. Of course, with the big chunk of money, 1 million. Okay, I would like to gamble and I think I can earn back 100%. Yeah, another 1 million from the gambling. Okay, this is the thought of the gambler. They thought of getting more from what they put in. So then they gamble away the inheritance and run away. Okay, maybe, get some more debts. 1 million gone, but later on, get some more borrowing and to gamble and run away. So now what happened to the children? This is a sad story. The children can only be sent to orphanage to live and taken care by the caretaker there. Yeah. So this is also a story where you can share with your client if there's any relevant, type of similar cases. Okay. Story 4. Okay, we digest one by one. Yeah. Story 4 is unregistered wife. Okay. A man and a woman have not registered their marriage. Okay, still boyfriend and girlfriend. So the man died in an accident without making a will. Since there's no marriage registration, the woman is not a legal wife. So where will the inheritance goes to? It will goes to the man's parents. Okay, regardless of this man and a woman maybe have been together for more than 10 years, 20 years, and actually the parents know the existence of this lady. Okay, but since they are not married, they are not husband and wife. Okay, so the man parents claim all the asset and do not give a cent to this unregistered daughter-in-law. Yeah, by law, this lady is just a girlfriend of my son. So I do not need to give any single cents to this person. Okay, so this is the story number 4. Okay, now story number 5. This is my favorite story, which which I always tell those divorcee, yeah, which is under the same circumstances to really, really look into, you need to do a estate planning, writing a will to do something. Yeah, okay. What is this story about? It's about an abusive ex-husband. So a couple divorced with an 8 years old child due to abusive ex-husband. For this case, unfortunately, is the ex-wife, yeah, passed away in an accident without making a will. However, this ex-wife has left behind a huge estate and some more the insurance proceeds where the ex-wife actually bought a huge sum assured for the children, for the sake of my children, which is still very young. I want to leave more money to my children in the event I'm no longer around. Okay. But this ex-wife did not know that under the Guardianship of Infant Act 1961, the surviving ex-husband is actually still the legal guardians of the minor. Okay. So what is this? If my ex-husband, which is abusive, come back to take care of my children, do I want that? Yeah, do I want this to happen? Can my ex-husband take good care of my children? If not, I won't divorce my husband, right? So let us look into what is the power of a guardian. Okay, so if a person has been appointed as the guardian of the person, okay, they shall have the duties of taking care of the minor's support, health, and education, upbringing, yeah. So what is the duties of guardian for property? Okay, under the Act, if you see clause 4, subject to the rights and power of any trustee or personal representative, a guardian of a property of an infant shall have the control and management of the infant property. ... Okay. So now the abusive ex-husband can come back and says, I'm the biological father of my children. Under the law, I am the legal guardians of the minor. So I have the rights to come back to administer whatever there is under my children's name, including the insurance proceeds. What if the insurance proceed is 5 million? Yeah. Can my abusive ex-husband really take good care of my children, not because of the estate? Okay, so I throw back this question to you, okay, for you to further digest. Okay, now the last story for today is Irresponsible Greedy Father. Okay, so this story is about the husband and his wife have been separated for many, many years, but have not yet divorced. But this is one the same as the previous one. Okay, but this is the cases back in 30 years. The husband left the wife and the son when the son is just 2 years old. Yeah, still minor. So this irresponsible husband just left the family just like that. And the wife stayed back, take good care of the children and raise up the son. Yeah. And after 30 years, the son was a successful businessman, but unfortunately died due to an accident. Okay. It's suddenly out of the blue, the missing father suddenly appeared. Okay. Just like magic. Chang appear, come back and to claim the estate distribution of the son. Yeah, can this be allowed? Yes, because the father is still the husband of the mother. They are still legally married. Yeah, still legally married. And the missing father can come and claim the proportion of the estate because of this status. Remember the Distribution Act just now? Yeah. If I have only parents, all my hard-earned asset will be given to my parents equally shared, 100% equally shared. So 50 to the my mother and 50% to my this missing in action father. suddenly come back to claim the estate. Yeah. So sad story, but hope all of you can, get something from this story where you can share with your clients. Yeah. Okay. Okay. Now, maybe we have more relaxed of looking at this, photos where you can see here now. Can anyone guess who is the, painter for this drawing? Yeah. Can you have a guess? Maybe you can type into the Q&A box where I can see the answer. Yeah. Can have a guess who is the painter for this drawing? Or you have any if you have this drawing in your collection. Yeah, okay, I got some of the answers already. Picasso, yes, Picasso. Thank you so much. Okay, Picasso, correct. Pablo Picasso. Okay. Oh, I have just noticed I put the answer there. I should remove that. Okay, everyone wants a piece of Picasso. So all of you know that Pablo Picasso is, well-known, painter. Yeah, Spanish painter, which passed away at the age of 91 years old, right? 91 years old. So for this case, it's not a story. It's a real case study where I want to, share with you, okay, share with all of you, what happens to Picasso estate. Okay, now, if you have time, you can also Google this, news, and also Google how is the consequences of Picasso empire, the estate. So Picasso passed away at the age of 91. So when he died, he left behind a lot of works, which is very memorable works. Yeah. And actually, huge sum of estate, which is now has been done. Okay, done. It has been done. But after 6 years of challenging here and there, yeah, suing here and there. Okay, supposedly there are 7 heirs, but each of them want a piece of Picasso. Some want more pieces, yeah. Everyone want more actually. Everyone want more pieces of Picasso. So this estate has faced a lot of problems, disputes. That's why there's a battle to this. Okay, so this is what happened when Picasso did not leave any will. Okay, the division of the holdings actually took 6 years. Yeah, with really negotiation among the heirs. Yeah, and how much is the settlement cost? 30 million. Okay, 30 million. If you're very, if you're curious about how much total of Picasso have, okay, you Google it later, yeah, you can Google it later. And the settlement cost paid to the lawyer is 30 million. Okay, 30 million. Okay, now we have heard of stories, yeah, we have heard of real stories when you do not write a will, what will happen next. So now, are you ready to have a will? If you have not written your will, please do so today and start fill up your form. Okay, don't wait tomorrow because we never know what will happen tomorrow. Everyone need to do your planning early. Yeah, just like all of you must have heard of the turbulent cases, a very serious one, Singapore Airlines from London to Singapore, and then they have emergency landing at Bangkok, which caused death of one elderly. Yeah, it's a very sad case. And as the expert says that the turbulence currently has been quite actively will be going on here and there. So during that turbulence, actually a lot of people panic. They start want to call their family members. They want to text their family members. Yeah, because they won't know what will happen next. Yeah. So when you are on a plan, for me, I think when we are on a plan, we are really put our life to the plan and the pilot already. There's nothing else we can do. We can just sit, we can just wait for the plan to land. That's all. When you're at the air, there is nothing you can do. Even text, even messages, even call. Maybe you have the Wi-Fi connection, but during the turbulence, we do not know, can you still on hold of your phones? Yeah. So don't do things like, don't do wheels when there is a panic situation. Okay. In the turbulence, suddenly you want to grab an A4 paper, you want to write quickly. There's no time for that. And suddenly when you collapse, when something happened to my health, I can't really do much. Maybe one day Nicole collapsed and then my hand is shaking, I can't think in a very sound mind way. I no longer can write a will. Yeah. Writing a will, you need to be sound mind, you know what you are doing, and you are healthy in doing that. Okay? So don't wait, do today. Okay? Next, I will be sharing on some illustration on family type and how we can, as the estate planner, we can advise them to write their will. So first is our basic will. This is a will package to provide solution to a group of clients with a very simple asset distribution. Yeah? Okay. Now, so case study number 1 is the basic will for Mr. Chan and Mrs. Chan, age 60. They are married, happily married, and you can see in the photo, they are very happy, still with the teeth. I don't know it's a real or fake one. Okay, just kidding. Okay, so family background, they have 3 adult children. All of them single, yeah. And their assets is very simple. They have 2 bank accounts which have their retirement fund there, and 1 property which they are living now. Okay. Distribution manner, when you ask Mr. Chan and Mrs. Chan, actually same to all asset. I do not split my thing. My Maybank to my son, my Hong Leong Bank to my daughter. Okay, no need. Everything same distribution. Okay, everything same. So option 1, this is their concern. Do I need to will to my spouse and also to my children? Option 2, can I exclude my spouse and just put my children as the beneficiary? Can I do that? Because some of them, they think my spouse already old, 60 years old. If I'm no longer around, I pass my thing to my spouse, 60 years old, she might, pass on after me. Then we will do another round of transfer. So some of them might have this concern. So as an estate planner, you can advise them, okay? Yes, you can. Option 1, you can put your wife as the beneficiary. Of course, if you love your wife. Yeah. Also, some of them might worry, if I pass away, I pass all my things to my children, they will kick the mother out. Oh, okay. This is some of the story lah. Okay. But solution 1, the option that concerned by the client, I want to give to my spouse. So can Mr. Chan just provide me with the information first. I would like to know who you want to appoint to be the executor for your will. Okay, remember the checklist, yeah, everyone. First is to choose your executor. Again, secondly, to list the asset and how you want to distribute to. So after you get hold of all this information, you transfer all the information to our will detail form and fill up section per section. Okay, section A is the personal data of the testator. Section B is the appointment of trustworthy executor. And fill out for section D, Mr. Chan, I will help you to list down all of your beneficiary. Okay, and just fill out section F, residuary estate. Okay, first layer is your spouse, 100%, main beneficiary. If my wife not around, then I would like to give to my the 3 children equally shared. Okay, equally shared 3 children. So just need to fill up the section F. And also I would suggest put section J as well, the common clause of 30 days to avoid double work of estate administration. Yeah, I would like my beneficiary to be healthy and survive more than 30 days, within 30 days of my passing, in order to inherit my estate. If this beneficiary pass away, Okay, within the 30 days, I'm so sorry, this person will not be the beneficiary. It will go to the next substitute beneficiary. So RHB trustee here, we always encourage, if can, put more substitute beneficiary, because we will know that what will happen to this main Benny. And if anything happen to this main Benny, the will consider there's no use at all, because the beneficiary that you put there, yeah, is no longer there. So it will drop under no wills, because the will cannot be done anymore. So that's why our side here will do a proper will. We will think further ahead. Okay. So option 2, just now Mr. Chan said, okay, Mrs. Chan told the husband, no need to pass to me. All give to the children. Okay. So everyone still remember the 4 VIPs, yeah, which is protected under our Family Protection Act: spouse, infant son, a married daughter, and handicapped child. These 4 VIPs can claim maintenance from the estate. So if you exclude them from become the beneficiary of your estate, you will need to give reason. Yeah, reason why. For this case, since Mrs. Chan has given out the consent, okay, let us mutually agree that we do not want to give to each other. Okay, we do not want to give to each other. We just want everything goes to the children. So they need to fill up another section, which is section J, to exclude spouse to be the beneficiary with the reason both of us have mutually agreed on the arrangement. Okay, so it can be done. Okay, so that is a basic will. Next, we will look into the comprehensive will, where this is the will package to provide solution to a group of clients with a more complex asset distribution. For example, like they have a lot of maybe bank's account, but each bank's account, they want to give it to a different person. Yeah. And also to cater for unforeseen circumstances, okay, which I will share in a short while here. Okay. So case study number 2, we're looking at Miss Lee. Okay, Miss Lee is the one that's sitting far right. Okay, far right, Miss Lee. She is 25 years old and she's single. Okay, so sit in the photo actually is his brother and also the father and mother. Actually, they quite look alike, yeah. Of course, it's family, right? Okay, so their parents, her parents is actually age 70 plus years old and only have maybe another 2 siblings. Okay, the assets is 1 bank's account, 1 apartment, 2 insurance policy, and 1 car. Okay, so you ask back, Miss Lee, how do you want to distribute your estate? So Miss Lee said, I would like to give it to my parents first. If my parents not around, then it will be given to my another 2 siblings. Okay, so this is the concern of Miss Lee actually. So Miss Lee tells you that actually I bought the insurance, it's quite huge amount, and it actually I nominate my parents to be the policy nominee. But I worry because nowadays, right, there's a lot of scam happening. And when those elderly, when they receive calls saying that your account been blocked, your how to say, your freeze, yeah, custom freeze your account or something like that, they will get scam and then just transfer away the money. Okay, so what can I do to protect my money, which is a huge insurance sum assured, maybe a few millions? Okay, and maybe can I hold these monies and my property until their lifetime to sustain their living maintenance? Okay, so Miss Lee have this concern because before meeting you, Miss Lee have read a lot of these, news about elderly people being scammed. Okay, this is a real paper cutting from the news Straits Times, where you see on the left-hand side, this is a true story. A Malaysian woman cheated of 1.3 million inheritance in a phone scam. Just like that. Maybe they just send a QR code or some of the link, you click and they can retrieve. So I would like to emphasize now with the AI around, yeah, AI is starting to manipulate Okay, and then scammer are getting clever every day. Yeah, they are well educated. They know how to take away our hard money. So we need to protect the money. Yeah, we need to get smarter than the scammer. Okay, like this one, 71 years old, retiree, losses 200,000 to a phone scam syndicate. Okay, this 200,000 might be the insurance payout from the loss of the daughter or the son. Yeah, so this is also a very sad case. By right, the money is supposed to let them have a better life after I'm no longer around. I want them to use this money to continue their life in a better way. Yeah, but being scammed off to another person. Yeah, so Miss Lee, I might need to advise you on few things. Yeah, you need to write a will for that. Okay. For first thing, you would like to appoint a really trustworthy executor to execute your estate. Okay. And you as well can execute individual. Maybe you trust your brother. Yeah. Your brother to do the execution, and you put RHB trustee to be the substitute, last substitute. Yeah, in case your brother is not around at that time or unable to act as an executor. Okay. Section D is the list of beneficiary who you want to give it to. Of course, the parents. Yeah. And if my parents not around, then give it to my siblings. Section E, list of asset. Should I put my insurance policy in the will? Actually, yes, you may put in, although it has nominee inside. Yeah, if nomination failed, for example, yeah, what if the person that I want to give it to, the nominee, failed? So it will drop under estate. So you need a will to claim the insurance proceeds. So that is why we need a big plan B. For anything, we need a plan B. Okay. Section F, residuary asset. Who will inherit your future asset? Just put down the names. Okay. And importantly, just now, Miss Lee, I know that you want to set up a platform that we can host the money and slowly distribute to your parents. You can set up the testamentary trust where you actually can slowly give your parents every month 5,000 of living maintenance. Yeah. Okay. So this is the solution for your client's concern. Okay, now study number 3, which is the last case study for today, is this comprehensive will of couple with minor children. Okay, so you're meeting Mr. Tan and Mrs. Tan, both of them aged 35 years old. If you can see in the photo here, they are happily married with 2 children, 2 minor children, 1 boy and 1 son. In Chinese, actually, we say is a word of good, Good. How? Yeah, because girl and boy, when they put together, my son and daughter put together, the wording is good. Okay, so concerns is, okay, Mr. Tan and Mrs. Tan, due to their job requirement, they often travel together. Yeah, they fly here and there. So thinking of the recent turbulence, they worry. What if both of us not around at the same time? Yeah. And eventually our insurance, we nominate each other. Yeah. This is very common among husband and wife. Okay. I bought insurance. I nominate my wife. So my wife also nominate me. But what if both of us not around? Okay. The nomination failed. The proceeds will drop under estate. So if drop under estate, family members will need to go and claim the estate, right? So without a will, someone names administrator will go and claim the thing. Who is this administrator? We never know because it's not whoever that I know that I appoint. It will be appointed after my passing, and it will be appointed by my family members. Can it be outsider? Yes. Yes, if given the consent by the family members, yeah, to give authority to a person to administer the estate, it can be done. Okay, so dangerous or not? For me, I think it's very dangerous because administrator have the rights to do many things. What if the administrator is the irresponsible one, take the money and run away? Okay, the money supposedly to give to this cute daughter and cute son. Okay, so next, the appointment of guardian. If me and my spouse not here, who will take care of my children? Who is the best person? If I appoint my parents, they are really too old for that. I worry it will be a burden. So I think I will need to find someone. Yes, of course. Husband and wife sit down, talk together. Appoint the best person that can take care of the children. Of course, before you appoint this person, please talk to this person first. Get the consent. Let them know. Yeah. Do not appoint, without their knowledge. Imagine this, yeah. Imagine this. You are the appointed guardian without the acknowledgement or information. Someone appoint Nicole to be the guardian of their children. How many children? 10 children. Will Nicole take it? Maybe two options. Okay, maybe two options. Maybe I give you, maybe you are in my shoes today, yeah? Nicole has been appointed as the guardian for 10 children. With option 1, there's no allowance. No allowance given, you need to take care of the 10 children. Option 2, you will take care of the 10 children with allowance of 50,000 every month. You want to take option 1 or option 2? Okay, you can type into the chat box, yeah? Do you want to be a guardian for 10 kids, 10 children with the allowance of 50,000 every month? Would you want to take it? So somehow, okay, there are some clients that when they appoint the guardian, they don't even look at the allowance because they did not think further ahead. Taking care of the children is just like you treat, that is your babies. That is the person you need to give love. You need to take good care. You need to have a good upbringing for the children, So you won't able to take care without any supports. You need allowance for that. Okay. So, yeah, I see there's a lot of option too. Of course, taking care of children needs a lot of money, energy, and money. Okay, I repeat, there's a need of money and also allowance for you to taking care. Yeah. For 50,000, I can hire a good nanny to take care of the 10 children, correct? We can have a good arrangement. Yeah. So, okay, now move on. So, you know that insurance trust, Privacy Insurance Trust is a very, very, very good platform where the client actually can absolutely assign the policy to RHB trustee. So whenever things happen to the client, the policy money will pays to RHB trustee to hold and to slowly distribute. Yeah, not to just pay off 100% to the beneficiary and maybe they will spend off, maybe they will be scammed off by other people we don't know. So they are interested to do, but they are concerned about the absolute assignment stamp duty, which is currently charged at 1 to 4% from of the sum assured. This is not charged by RHB trustee. This is charged by the income tax. So this money need to be paid by customer during lifetime before anything happen. Before they can even touch the insurance money, they need to fork out money to pay for the absolute assignment fee. For a 1 million assignment of a sum assured assignment, you actually need to pay roughly 20 over thousand to income tax. So they are interested, but too expensive. Yeah. So they can actually use testamentary trust. Yeah. In the event me and my spouse pass together, nomination fail, our insurance proceeds drop estate, my will can kick off the backup plan. The estate of the proceeds is to be given to my 2 cute children equally shared. But before they reach 18 years old, I would like to slowly give them money. Yeah. And when they reach 18 years old, I will get the testamentary trust to hold the money. I do not want to give them the money. Yeah. Because as I always say, when you are age 18 years old today, when you have 5 million in your bank account, first thing I will do, I will spend. Honestly, I will spend. I will buy, will do whatever that I like. go travel around the world, yeah, spend whatever that I like, but I will buy a Ferrari, I'll buy here and there. So it will spend. First thing to do is spend the money. They won't feel the pain of spending because the money is not their hard-earned money. Yeah. This is the truth about spending money. Okay. So how do we want to give a good solution for this couple? You will need, both of you need to write a will. Will for husband, will for wife. And both of you, please discuss together who you want to appoint as a trustworthy executor. Be it the first layer executor is maybe your spouse, yeah, because you trust your spouse, yeah. I got cases that they don't even trust their spouse, okay, special case. So they can also appoint RHB trustee to be the executor. We can be the last executor, yeah. And C, appointment of guardian, and also important, yeah, allowance to guardian. So when I talk about allowance, when I talk about monthly payment, and when I talk about we hold some money to give to the future children, yeah, where will this money come from? It's come from our asset. But remember this, upon our demise, we need to pay off our utang first, our debts. Yeah. If the utang is more than our assets, the worst case is we do not leave anything for the children. We do not leave anything for my spouse. What we are leaving behind? Our debts. They need to pay our debts in order to continue their life. Is this what we want to see? No, right? So we need to think of funding. Where should I get the funding? There are only two choices here. First, you need to work hard, day and night, 7/24, to get more assets in, to cover whatever debts that you have now, to overcome the debts. Yeah. Overcome the debts, I still have balance of this money to sustain for my children. Secondly, a fixed thing, funding that will pay off to you, not to you, yeah, pay off to your family member if we kick the bucket. What is that? Insurance. Okay, you will need an insurance to make sure that this money is enough to cover for your debts, enough to cover for your future children living maintenance, and also to their spouse as well. So, okay, this one I give you the tips already. Yeah. So section D is the list of benefit. Section E, list of asset. You can put in the insurance policy as the backup plan. Section F, the residuary estate. Who is the beneficiary for future estate? So talking about future estate, yeah, when we do planning for a couple with children, normally where we stop for the beneficiary, of course, stop at the children there, right? Children. But as an estate planner, we will think further ahead, more further ahead. We will throw question to your client. What if, yeah, what if your spouse and your children also not around together with you? Yeah, we know that, yeah, during holidays, you all will have go to a trip. We never know. So what if all not around? Who is the next layer of money that you would like your hard-earned asset to be given to? So when you tell them about this, they will show you a very blank face. Yeah, because they never thought of this. To be honest, I never thought of this before. Yeah, I didn't think that it will happen, but we never know. Yeah, so you should put another layer in case spouse and children all not around. Next layer. Okay, so section G, in order to hold some of the, big sum of money if me and my spouse not around, I would like to drop it under testamentary trust. And please remember, testamentary trust can only be set up when all the debts has been paid off. The balance of the estate will be set up as testamentary trust. Imagine this, your debts is far more than your assets. You have pulled all the asset to pay off the debts, nothing left to set up the testamentary trust. So there will be no testamentary trust. So funding is important to make sure that the Section G testamentary trust can work well. Yeah? Okay. So now, one question to all of you. Have you fulfilled your yearly maintenance criteria? Because now it's already middle of the year, June. Okay, just to remind all of you that if you are registered under our agency structure, you will need to fulfill our maintenance criteria of 2 cases per year. Okay, as you all recently received our circular saying that if you not being active, you are inactive, you need to reinstate your license, you will need to pay for the reinstatement fee of 500 ringgit. Okay, 500 ringgit. I just almost want to say 500,000. Get shocked. Okay, 500 ringgit to reactivate your license in order for you to submit cases next year. So please don't pay the 500 ringgit. I do not encourage. Talk to your client or even write the will for your own self. Yeah. Or even if you have written your will, never mind. Have a review on that, because I know that some of some of you have written but not really fully satisfied. Just like what I say, maybe my beneficiary, I only put my spouse and my children, but not enough. You need to put more. Okay, you can rewrite anytime you want. There is no restriction, because there are some cases I've been told client written a will with some parties, some firms. Then the firm said, I already seal your will. Yeah, I already seal your will. You cannot take it out. You cannot see your will. You cannot tear the seal out, because when you tear the seal means the will is no longer valid. This is something that I heard, which is untrue, where you as the owner of the will actually can see your own will. Okay. And next, the reason I heard is the person wrote a will with Amanah Raya. Okay. Then Amanah Raya told the person, if you have any additional assets in the future, you can just update right on your will using pen, right on your will. It is a big no-no. It's a big no-no to do any writing, on your existing will, which you have already signed with 2 witnesses in front of you. Even if you draw cartoon, even if you draw cartoon, big cartoon, your kids take out and big draw cartoon, the will has been tampered. Okay, please do not do so, because it will the validity of the will be questioned. Okay, so keep your will safely. We have the custody services, where our custody services is a whole life fee, where you can just need to pay one off, 1,000 whole life. We say keep the original will with us, then you will get a will retrieval cards in return. Okay, in return, to inform your executor or your family members, if anything happened to me, my will is safely kept with RHB trustee. You can contact them and claim the original will. Okay, so the how to say, what else to ask? Okay, the will which has been somehow when you take a look at the home, you keep it somewhere, and water, white ants destroy. All these will also affect the validity of the will. Okay. Okay. So before I move forward, maybe I will see. Okay. A lot of you has asking for the slides. Yeah. I know. I understand. We will upload the slides into, we will upload the slides into our digital library. Okay, which I will show you the link to get the digital library later. Okay. And let me have a check on the Q&A box. Okay. Okay, presentation slide we will provide in the digital library later. Okay. Okay. Now, let me read out the questions from this sheet. If a person already write a will and beneficiaries are mother and husband, If mother died before will execute, okay, means mother passed away before me. The mother part will fall to Amanah Raya. Oh, no, okay. It won't fall into Amanah Raya. Okay, to fall to Amanah Raya actually is quite a myth, okay? Not all estate will drop to Amanah Raya unless you get Amanah Raya to do the application or probate or do administration of the estate, yeah. So if a person have written a will, the beneficiary is mother and husband. The mother passed away already, so the mothers will not be the beneficiary. The mother portion will be given to the husband. If in the will only mention my asset will be equally shared between my mother and husband. If any of them not survive, another surviving will get the whole portion. Okay. Okay, so this is done. Okay. Okay, so we have these questions as well. I have a friend mentioned his friends passed away with the wife passed and no children, but parents surviving. Wife his estate cannot pass to his parents as per the entitlement for the first spouse. Okay. Surely this one I can't comment much because I did not know the process of how they claim and what happens in between. Okay, so maybe later after this session, you may contact me to get to tell me the whole story lah. Okay, can I get the slide? Oh, okay, the slides I repeat we will upload to our digital library after today's session. Yeah. Okay, so okay, so does divorce make the father not entitled to child estate? No. Divorce only make a clear cut from the spouse. Clear cut from the spouse, but not the children. Okay? Not the children, yeah? Okay, from child, if a will is made in contemplation of marriage, then when married, the will is valid until marriage. No need to make another will unless need to make changes. Yeah, Chong, correct. So just a refresher, when you are single, right? For example, today, Nicole single, Nicole written a will, and 1 year later, Nicole get married. So the will that I have written during my single time, it will be auto revoke. Yeah, it will be auto revoke. But another scenario, for example, Nicole, today I have a partner. Yeah, but we are planning to get married. So in the will, if you do not want this will to get revoked upon our marriage, so you can tick on this will is made when we are getting married, contemplation of getting married. So it will not affect the will when I get married. Okay. Okay. Now let us see some more of the questions. Okay, some question. Also, EPF or unit trust already have nominee. Okay, in Malaysia, there are two things that we know that we must put nomination, which is first our insurance, second our EPF, and some unit trusts they have this trust nomination where you can put nominee for the unit trust. Yeah, this one you need to check back with the fund house whether do they have the trust nomination platform. Yeah, so those with nominee is stronger than in the will. Means whoever that you put as nominee in your insurance, your EPF, or your unit trust, it must follow that layer first. Unless it's fail, it will go under estate. So under estate, will is needed to get a faster way to administer the estate. Okay, I can see there are a few question about charges here. Okay, for charges, you can refer back to the will detail form. Okay, you can refer to the will detail form. Can I appoint anyone to be a guardian? Yes, you can appoint anyone to be the guardian. Yeah, make sure that you appoint someone which is trustworthy and can take good care of the children. Yeah, it can be anyone. It not needed to be blood ties. Yeah, it not needed to be blood ties. But remember again, please talk to that person before appointing. And also executor, you need to write a will and being informed for the executor, because executor is the person that will look for your original will when things happen. Okay, I remember 20 years back, Nicole asked me to be the executor, and she informed me the will is safe kept by RHB trustee. I will need to contact RHB trustee. Okay, imagine this, you have written a will without anyone knowing. You diam what? I do my will, no one knows. If anything happened, no one knows you have written a will. It's actually equivalent to no will because no one knows. Yeah. Even like you appoint A to be executor, but you did not tell A that you written and where you keep the will, A will not do anything. Okay? A will not do anything. Okay. Okay, one question. If the client previously written a will, can he keep the will with RHB? Sorry for that. Our RHB trustee will only keep will written with RHB trustee, yeah? Okay? Okay, so next, let us see what else. Okay. From Chin, single also can be guardian. High Court will approve. Okay. Appointment of guardian, they can be by appointment by the parents via will. So single also can be guardian. Yes. But if you have this hesitation, can a single person take good care of my children or not? Because they don't have any experience in taking care of children, right? So there are many factors that you need to think of to appoint someone to be guardian. Yeah. Can this person, if the person don't even know how to change diaper, do you want to appoint this person? Right? So okay, just an example. So you need to talk to your spouse, or even if you are single parents, you need to talk and know more about this person, whether, hey, can this person will be the best guardian to take care of the upbringing of my children? Yeah. Will this guardian can beat my kids or not? Yeah. All this, yeah, need to be taken care of. Okay. Okay, so all the charges, right? I noticed there are lots of questions about charges. Please go to check into our will detail form. We have page number 16, page 16, where you can see all the charges there. Okay, all the charges there. Okay. Okay. Now, I have gone through the Q&A box. Let us see the webinar chat. Okay. I will pick those questions which is relevant to today's topic, yeah? Is this a real case or just scenario? Okay, Suki, there are 6 stories which is just a scenario just now. Okay, then the real case is the Picasso one. Okay, Picasso one. Okay. Okay, from Theo, can the guardian touch estate if the deceased have a will? Only the executor can manage his estate, right? Correct. Theo, correct. But if a will, you have appointed executor. Executor is the one who holds the money. Okay, money executor. Remember that money executor. Guardian, if there is any allowance, you need to get from executor. Okay, so just now when I talk about dealing with those estate, right? Imagine this person do not have a will, okay? Then do not have a will. The guardian, okay, the guardian of the children can actually apply to be the administrator. So imagine when your guardian is also your administrator, and this person is not your spouse. Dangerous or not? Or even if the person is your ex-spouse. He is the executor, he is the guardian. Very powerful. Okay? You can touch the money and also do anything on it. Okay, it's very dangerous. Okay, now let's see other questions. Charges again. Okay, charges again. Charges, you can refer to the forms. I would not elaborate more here. Okay. Okay, this question from Eileen. If RHB trustee was initially appointed as executor, okay, after testator passed away, can the beneficiary opt to change the executor? Okay, in this part, it is subject to many scenario. Okay, many scenario. First thing, if RHB trustee has been appointed as the sole executor, by law, we are the executor for the estate. Okay. But if there's the beneficiary says that I would like to renounce, I do not want RHB trustee to be the executor, first, you have been object to the initial arrangement by the testator. Okay, you object the arrangement and you will need to appeal for the renunciation, which is subject to our approval, management approval. And of course, also if really need to go to court to everything, also need to get court approval for that. Okay. But while testator is alive, can he or she change the executor to someone else? How about paid appointment fee? Okay. While the testator is still alive, okay, this person can do any changes he or she wants. Yeah, he or she can do any changes to change to someone else, to remove this person as executor, to replace this person as executor. And how about the pay appointment fee? It won't be refunded. Okay. Initially appointed RHB trustee, but now change the mind. Okay. Nicole changed the mind. Today I have trust this person. I trust Eileen so much. I want Eileen to be my testator. So I changed to Eileen. But the previous paid appointment fee, sorry to say, it won't be refunded. Yeah. And third scenario, there are some cases, right? RHBT has been not appointed. We are not being appointed as the executor for the will, but eventually after the family member gets the will, right? They say the son saw, okay, my father appointed me, the daughter, or the daughter to be the executor number one. But I want to appoint RHB trustee to be the executor for this will. Can or not? No, cannot, yeah? Cannot. Executor can only be appointed by testator, not the beneficiary. Okay, not the beneficiary. Yeah, you cannot just appoint RHB trustee to be the executor for the will upon the testator already passed away, and initially the testator did not appoint us to be the executor. Okay. Okay. Now let's see. Some questions here. We take another one. Yeah. Okay, there's no recording video for this review. Understand that they got work, can't attend. But after you have listened to this, my sharing, and also my slide is also very transparent. The story are all there. They can have a read themselves, yeah, and you can just share whatever that you heard today, yeah. Okay. Okay, so I think that's about it for today. Now it's 11:30. And if you have not downloaded our flipbook, which we launched early of this year, we have this 2024 Kick-Off e-handbook. You can download, you can take out your phones, you can screenshot this flipbook QR, download our flipbook and to see what is our campaign for the year. Okay, just a brief, we still have 4 weeks to go for our Omakase challenge. Yeah, Omakase challenge. You can still have time to hit 1 ticket. Yeah, for that. Yeah, you can scan and download. And our iPad Pro challenge, 100 wheels with 70,000. You can get one iPad Pro for the first estate planner who submitted. And the third campaign is our Bali trip. Yeah, Bali trip until end of the year. Okay, iPad Pro also until end of the year. Okay. Now, just now, yeah, everyone is asking me the same question. Can I have the slide? Can I have the slide? Yeah. Please scan this QR, but I will only upload this after the training later. Yeah, not now. You can take photo or just scan the QR here to get ready. It will be under the course material. Yeah, course materials where you can download the slides. Okay, but please, I would like to seriously inform all of you, the slide is for internal training reference only. Yeah, do not share out, do not really, share around, publish in newspaper or whatever, right? So just for training purposes, especially because some of the sensitive things inside, although I have put disclaimer, right? Please protect this material within the group. Okay. So hope you all can get the digital library. Okay, this is purely strictly for estate planner use only. Yeah. Okay, so that's it for today. I will not prolong the session for today, hopefully not too long. And our tagline for this year is secure tomorrow, you will need to plan today. So if you have not written your will, please start do so. Start filling out our will detail form today. And please help friends and family around us to do their estate planning. Okay, so see you all tomorrow for our trust training. It will be conducted by my senior BDM, Mr. Jeffrey. So stay tuned for that. So see you all tomorrow at 10. Okay, thank you so much.